Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. A big part of my practice is suing credit bureaus such as Equifax, Experian, TransUnion, and furnishers of information, those who provide or furnish information to the credit bureaus. So this is under the Fair Credit Reporting Act, the FCRA. Today, April 28th, there was a great decision by the 11th Circuit, which that covers the federal courts in Alabama, Georgia, and Florida. Now, there's one thing I think that the court got wrong about this decision, but overall it's a very good decision, very, very helpful to consumers. So if you're interested in not just hearing people talk about what the law supposedly says, because a lot of times they get it wrong, if you want to look at the actual law, then join me in this video and we'll look at this. So you can see this is the 11th Circuit, and this involves NationStar, or they have this goofy name of Mr. Cooper, whatever. And Experian, that's one of the major bureaus. And this was April 28, 2021. This came out of Florida. So let's see what we're dealing with here. So the consumer was in dire financial straits, so he files Chapter 7, discharges his debt. So Chapter 7, sometimes called straight bankruptcy, just wipes out the debts. There's a few exceptions, but mortgage debt can be wiped out. But he discovers his credit report still showed he was delinquent on the mortgage, even though the mortgage was wiped out. How is that possible? So he contacts the reporting agency Experian, but Experian's own inquiry with its data furnisher, that would be NationStar or Mr. Cooper, led it to confirm, inaccurately as it turns out, its previous reporting. So it continued to report this, and so he files suit under the FCRA, Fair Credit Reporting Act. So here's a couple of things the court has to decide, because the district court said, hey, Experian did everything right. I'm throwing your case out on what's called summary judgment. So the court has to decide, all right, did Experian employ reasonable procedures to assure maximum possible accuracy? Now that's section 1681 EB. And then number 2, did Experian conduct a reasonable reinvestigation of the disputed information, that's the NationStar mortgage, that had been discharged, when notified of a potential inaccuracy? That's section 1681I. So EB is maximum possible accuracy. They always have that obligation. But I comes into play only when you dispute through the credit bureau. And you can think of I standing for investigation. So the district court held Experian did not violate the FCRA grand summary judgment. The court says we disagree and we vacate that judgment. So now the court's going to take a step back. Tell us what some of the facts are. So 2012, consumer had a city mortgage in Apopka, Florida. So as I remember, that's sort of a suburb of Orlando. In 2017, declared Chapter 7 bankruptcy. He wanted to keep his house. And so he reaffirmed, that means he's obligated again on this mortgage. So the debt was discharged, but then with the court's approval, you can voluntarily agree to the debt again. So that's what he did, reaffirm. But somehow, and the court's not sure how, the trustee, the bankruptcy trustee, sold the property. And then City Mortgage transferred the servicing of that debt to NationStar. So since he didn't have the property anymore, he said to the bankruptcy court, hey, rescind or tear up, undo the reaffirmation. And the bankruptcy court did that. So believing he had a fresh start, he was dismayed when he found his Experian credit report still showed he had debt with NationStar. Remember, that debt had been discharged, nearly $140,000, past due amount of $10,000. So in June 2018, so remember if we back up, in 2017, he filed the bankruptcy. So a year later, he says, look, I'm disputing this NationStar mortgage account. He gives the account number. This was discharged in my Chapter 7 bankruptcy. I filed 2017. We filed a reaffirmation, but we rescinded that in 2018. And so I no longer own this debt. You could also say I no longer owe on this debt. Please correct this information. So what does Experian do? Well, they send an automated consumer data verification. That's an ACDV form. We have a whole video on what's ACDV and eOscar and all that sort of stuff. It just, think of this as, this is the method of communication. eOscar is sort of like the pathway or the telephone line. The ACDV is the form that you send on that. to NationStar seeking to verify the alleged debt. NationStar said, hey, it's correct. Correct balance. They added past due amounts that since accumulated. So Experian relays that to the consumer, and Experian does nothing else. So all they do is they reach out to NationStar and say, what do you say? And we're just going to repeat back what you say. NationStar says it's right. They send it back, so Experian just parrots back what their furnisher told them. So he sues them, and now once he sues them, then amazingly, they fix it. Okay, very typical, very typical. So he files suit in December 2018, and you can see just a couple months later it's fixed. And he brings that suit against Experian and NationStar, but only the claims against Experian are relevant because he's settled. Now, as the court says, here's a little bit of lingo. So when you're looking at statutes, a lot of times they'll define terms. So the consumer is the consumer here, okay? Equifax is a consumer reporting agency. Now, that's true. What they mean to say is Experian is a consumer reporting agency that creates consumer reports. These are also called credit reports. So those are provided to a user of the information, okay? Now, there's also what's called a file or a consumer disclosure. And we'll get into that a little bit more. It doesn't really matter here. But a credit report compiles information provided by furnishers. Well, who's a furnisher? NationStar would be a furnisher because they provide or they furnish information to the credit bureau. Okay, so let's go back to our text here. So he's amended the complaint a couple times. Here are the basic theories. Hey, Experian, you violated 1681 EB. Remember, that's maximum possible accuracy. And that's true whether or not you do a dispute. Okay. And then number two, he said, Experian, you did not conduct a reasonable reinvestigation after receiving my dispute letter. That's at 1681I. Remember, I is for investigation. Number three, this is all related to that I claim. You didn't provide NationStar with all relevant information. Number four, you did not correct or delete the dispute information from the credit file. Again, that's under section I. So he said, look, these were willful violations. So I get punitive damages and statutory damages. And also get attorney's fees. Now you get that even if it's not a willful violation. And then he said he's entitled to damages. Those would be what are called actual damages or compensatory damages to compensate you for Experian's negligent non-compliance with the act. So the district court, that's a trial judge in federal court, threw out the case and said the actions of Experian were reasonable as a matter of law. And so notice what the court said. The statute does not impose any duties on the credit reporting agency, the Experian, other than notifying the furnisher, NationStar, of the dispute and then examining the information. So what this judge said, and this is what the credit bureaus always argue, is they say, we get a dispute, we're not supposed to do anything with it other than send it to our furnisher. And then whatever our furnisher reports back to us, we just parrot, we just repeat that back. And then the court said, you should have provided specific information to Experian from which it could have discovered he no longer owed money on the NationStar. And because you didn't do that, you lose. And this idea of, hey, the debt was discharged, that's a bridge too far because it would require Experian to examine court orders, and that's a legal dispute. And so we don't do anything like that. And the court's going to say, you got all of it wrong. Okay. And so he timely appeals. And I do want to drop down here. This is continuing that footnote, just sort of explaining what happens here. Summary judgment is appropriate where there's no genuine issue of material fact. So what's a material fact? A dispute about a material fact is genuine if the evidence is such a reasonable jury could return a verdict for a non-moving party. So classic example, you and I are in a car wreck. I say I had the green light. You say you had the green light. We collide in the intersection. One of us is wrong. One of us is right. Well, that's not supposed to be resolved at summary judgment because if a jury believes me, then I win. If they believe you, you win. And so they say also we can affirm if there exists any grounds for doing so, whether that's what the district court relied on. Okay, so let's go back now. They say, before we reach the merits, we have to ask this threshold question about standing, Article 3 standing. Does a consumer have standing? Okay. We're not going to dive into the details of this. You can read the opinion, but it does touch on damages, which is very, very important here. And they say he does have standing under both of these claims. Remember, 1681EB is maximum possible accuracy. 1681I is the investigation claim, or what's called reinvestigation. The reason I call it reinvestigation, theoretically, they're supposed to sort of investigate it as the information first arrives to the credit bureau. So now you're asking them to look at it again to reinvestigate. All right, so let's go to, this will be the bottom of page 7. It says a consumer does not need to show the false reporting caused his credit score to plummet. The false reporting itself was the injury. This is really important because every time we bring these cases under the FCRA, the defendants say, well, did it hurt your credit score? Now, the funny thing about that is we question them under oath. We say, hey, having this collection account that's updated every month that says I owe $5,000, you agree that lowers my credit score? And the credit bureaus go, we have no idea. We are completely clueless on credit score. It may help your credit score. We're like, really? Your sworn testimony under oath is having a big old collection account helps my credit score. They're like, we don't know. Okay, they're just idiots and they're liars. Okay, but the point is they make that argument that you have to have a drop in your credit score, and the court's going, no, 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 no. The injury is the false reporting, regardless of what it does to your credit score. Notice this. The consumer does not need to show that the false reporting of the mortgage would be worse for his credit score than true reporting of a discharge and bankruptcy status. See, Experian saying, well, if we had reported it correctly, we'd say discharge and bankruptcy. That would actually lower your score. And the court goes, we don't care. The injury isn't the one to his credit score, but rather the false reporting about his debt. Then Experian says, well, you can't show that your report was sent to third parties. And the court goes, well, your report shows it was supplied at least 26 times. And they go, oh, those are soft inquiries. Soft inquiries don't matter because they don't affect your score. Again, now this is me talking. The FCRA doesn't distinguish between soft inquiries and hard inquiries. And well, this causes a score drop. This doesn't cause a score drop. It doesn't get into that. Okay. The fact is, under an EB claim, at least in the 11th Circuit, we have to show that the report was sent to somebody. Well, we just look at the report and we see all these soft pulls. Now, if we have a hard pull, that's very easy. And so for the soft pulls, Experian says most are just pre-screen inquiries. And so they don't really see your full report. But the court goes, well, when you say most, you acknowledge the possibility a creditor receives the full report and admits it can't say for certain whether the NationStar account was disclosed in connection with these pre-screen inquiries. I'll tell you this. We have gotten credit reports in discovery from a company that pulled our report, and it shows up as a soft inquiry. It's a full-blown report. I'm not saying all of them are that way, but they can be just, 30, 40 page, full tri-merge report. And so this idea that the credit bureaus, these lies that they tell about, oh, well, soft inquiry doesn't mean anything. That's just complete garbage. All right, so they say, look, evidence of inquiries is sufficient to show it was sent to third parties. And then they say you have emotional distress and you spent time, and those are damages. And he said he suffered from stress, anxiety, lack of sleep. He spent all these hours trying to correct information. And Experian says, well, we got two arguments on that. Number one, you can't tie that time, not all of it, to us. And most of the emotional stress and time he spent resulted from the bankruptcy itself. He spent at most an hour dealing with his dispute to Experian. So what? It still is an hour, okay? Because there's no question wasted time is a concrete harm. He has standing to pursue as long as even a small part of the injury is attributable to Experian. And then the emotional distress, I go, oh, well, he gave a self-serving affidavit. This is just the common expression all these defendants use. They say there's no way you can get emotional distress. It's self-serving because you testify that this bothered you. Well, every affidavit you offer by a party will be self-serving. Trust me, Experian will offer these affidavits, say we did everything right, nothing wrong. Guess what? It's self-serving. If it wasn't self-serving, they wouldn't offer it. That's just a ridiculous argument. It's like when we're in jury trials and somebody says, Judge, we object to this. This evidence is prejudicial to my client. We just kind of look at them and start laughing. Assuming we have a good relationship with the judge and the jury, we go, of course it's prejudicial. I wouldn't offer it if it wasn't prejudicial to your client. I'm obviously offering things that help my client and hurt you. And the judge kind of chuckles and goes, overruled. All right. So, according to Experian, a plaintiff's self-serving affidavit standing alone can't prove emotional damages sufficient to survive summary judgment. And they go, that runs in headlong into our en banc decision. En banc just means the entire court considered it. Normally, these appellate court decisions in federal court are 3-judge panels, but occasionally it'll be the whole 11th Circuit. In United States v. Stein, which we held a non-conclusory affidavit which complies with Rule 56, that's summary judgment rule, can create a genuine dispute even if it's self-serving and or uncorroborated. And statements regarding stress, anxiety, lack of sleep are not mere conclusory recitations of a damages element. In summary judgment, we must take the non-movement's facts, the consumer, as true. Go back to my car wreck example. I say I had the green light. You say you had the green light. I file summary judgment against you, and you say, look, I had the green light. And I go, that's self-serving. Well, obviously it's self-serving. Well, the court has to believe you unless there's some really, really strong reason. Now, some judges forget this, but this is the law. And so they say, look, you have Article 3 standing and you raise a jury question about damages on the merits. So they go, now let's look at the merits. So Section 1681E, that's at EB, maximum possible accuracy. Reasonable procedures to assure maximum possible accuracy about an individual. Now, the other one is the I claim. It says if the completeness, so that tells us something. If something is incomplete, then you can dispute it. Or accuracy. If it's inaccurate, you can dispute. Of any item of information contained in a consumer's file is disputed by a consumer, the agency shall, not, it's a good idea, we'd really like you to Experian, you shall conduct a reasonable reinvestigation to determine whether disputed information is accurate. Let me just pause here. What about biographical information? Can you really dispute that? If the completeness or accuracy of any item of information contained in the consumer's file, is your name contained? Is your address, phone number, place of employment, date of birth, social security? You see the point. Well, can you dispute inquiries? Because the credit bureaus will tell you can't. Well, let me read this again. If the completeness or accuracy of any item of information, so inquiries. So if an inquiry was made without a basis, in other words, if it's inaccurate or incomplete, then you can challenge that. All right. So now they're flipping back to Section 1681E. That's that reasonable procedures to assure maximum possible accuracy. Here's what you have to show. That a report contained factually inaccurate information, the procedures it took in preparing and distributing. Not every circuit agrees with that, but the 11th Circuit says you have to have that report go to somebody. If you can show they weren't reasonable and you have damages, then you have a good claim. Now for I, it focuses on the file rather than the report, except you don't have to show it distributed a report. So in other words, if nobody looked at your credit report or your credit file, you see an inaccuracy, you dispute it, they don't fix it, you have a claim under 1681I, even if nobody ever looked at your report. So a consumer report requires communication to a third party, a file does not. And so they say this is not really material here. Okay. So again, some people get sort of obsessed with it. Just remember for EB, you have to show that that report went out to somebody. For an I claim, you don't have to show that. You can be the only one that looks at your report, but you have an absolute right to an accurate, complete credit report. And if you notify the credit bureau there's a problem and they don't fix it, then you can sue them under Section 1681I. So they say, look, this will be a jury question in the overwhelming majority of cases. So plaintiff may recover damages for both negligent and willful. And they say, we're going to start with negligence because they ultimately throw out the willful. All right, so they say, look, here's a threshold issue. Is there actually factually inaccurate information. This is something that we get in, I won't say arguments, but people sort of, will disagree with me and go, well, no, I don't have to prove that it's wrong. I can just do these generic disputes and the Bureau must prove it's right. That's not the way the courts interpret it. Okay? Maybe they should, but here's exactly how it's interpreted. You must show that there is a factually inaccurate information. Experian says, no, there's nothing inaccurate. They say, okay, we agree the bankruptcy court discharged a mortgage, and so you're no longer personally obligated to pay the outstanding debts, but a bankruptcy discharge is merely an injunction or a prohibition against certain means of enforcing the debt, not an expungement of the debt. So we did nothing wrong by saying this debt still existed. And the court says, well, look, the premise is right, but the conclusion doesn't follow. So you're right, Experian. Bankruptcy doesn't expunge a debt. Like if you've ever heard in criminal, like you might have your criminal record expunged, that means wiped out. So we don't wipe out the debt, but they're saying what you reported is factually inaccurate. So you didn't just report the existence of a debt. So let me give you an example. So I have a Capital One card. I filed bankruptcy. I discharge it. That doesn't mean that the Capital One can't appear on my credit report, but it means they can't show that I owe the debt. They can't show that I'm late. They're talking about after the bankruptcy. They can't show that I'm currently past due, okay? Because the debt doesn't exist as it relates to me in a practical manner, okay? I don't owe any more money on it. And so they say Experian didn't just report the existence of the debt, but also the balance that was owed, the amount that was past due, how long was past due. So here's the May 2018 report. It said as of March 2018, you owed $139,000. You had past due of $10,000. You're more than 180 days late. None of that was true following the bankruptcy. He was no longer liable for the balance, nor was he past due on any amount for more than 180 days. And they reference a Supreme Court case. Discharge means that the debt will not remain on the credit report. Again, generally talking about like a balance or saying that you're late on it. So having concluded they reported factually inaccurate information, now we turn to whether Experian reasonably discharged its report preparation, that's section 1681EB, and reinvestigation obligation 1681I, I for investigation, by forwarding an ACDV form regarding the contested information to NationStar. Our circuit hasn't had much occasion to address the meaning of reasonable under section 1681E or I, so we look at other courts. They say our sister circuits have laid out two corollary principles. First, procedures will not be deemed unreasonable unless agency has a reason to believe the information supplied is unreliable. So what they're saying is it's pretty hard to bring just a pure EB claim without a dispute unless there's something about the information that should trigger in the credit bureau's mind, hey, this is not right. I'll give you an example because we see this a lot. There's missing data. That ought to trigger something. Or it says in May, you're current, and in June, you're 60 days late. Okay, that's just flat out wrong. Or Equifax will report the date of first delinquency, and let's say that's May 2018, and they said that's when you started becoming delinquent. And then you look at the payment history, and it says you're totally current in May. Obviously a contradiction there, okay? So they say, look, lenders report millions of accounts daily, so to examine each report individually would be unduly costly. But on the flip side of the same coin, where, for example, Experian has been notified of potentially inaccurate information, is in a very different position than one who has no such notice. That's because once a claimed inaccuracy is pinpointed, a consumer reporting agency conducting further investigation incurs only the cost of reinvestigating that one piece of disputed information. And the 11th Circuit says, pretty smart, and we adopt those principles. So we cannot say Experian's procedures were reasonable as a matter of law. Once he informed Experian of factual inaccuracy, he needed to only investigate that single alleged error, thus in a very different position than before he contacted it. And they say now, any claims that you have under EB for before you disputed, we get rid of those. So that's why we say almost universally, at least in the 11th Circuit, okay, you spot an error, you need to dispute that with the credit bureau, give them a chance to fix it. If they don't fix it, now you have that I claim, lousy investigation, and the EB claim, assuming they produce the report. And look, they're sending copies of your reports to people, every month. Okay, so that's usually not a problem. So Experian says, well, this is unique. Cut us some slack because this was a confusing and unusual bankruptcy. It's interesting. They're going to argue that they can't possibly understand court documents, so I don't know how they would know it's confusing and unusual. But anyway, so remember, he reaffirmed his mortgage and then he rescinded it, tore it up. And they say nothing in the bankruptcy docket indicated it went from city to nation star. And they say determining the legal effects of a discharge order is precisely the kind of legal question that credit reporting agencies are neither qualified nor obligated to answer. And they say, no, actually, you're completely wrong. They say to be sure, reasonable investigation does not require credit bureau to resolve legal disputes about the validity of the underlying debts they report. That's what courts say. I'm just telling you that's actually wrong. Okay, that's against what the FCRA actually says, but this has become popular among courts. Okay, so we had this big battle over, is this a legal dispute or a factual dispute? But they say, we haven't asked you to do that here. The bankruptcy court's discharge was unclear, but the mortgage was discharged. Like, you could have figured that out. Like, wait a minute, maybe the name has changed, but the mortgage was discharged. Thus, this case doesn't involve a legal dispute. I mean, the judge has already decided. There's nothing to interpret about it. They say this is more similar to Collins versus Experian in the 11th Circuit and Dennis versus BEH in the 9th Circuit. So Collins involved facts materially indistinguishable from those here. So Experian forwarded an ACDV, remember, Automated Consumer Dispute Verification Form, to its data furnisher, but did not conduct any independent investigation. When the furnisher inaccurately confirmed the information, the consumer sued. They say, hey, a fact question, so no summary judgment, remained as to whether Experian's investigation was reasonable when it disregarded the information the consumer provided, instead relied solely on the data furnisher to verify the debt. And then that 9th Circuit case, Dennis, is similar. So this involved a civil claim judgment that the credit report said a judgment was entered against you. Actually, the case had been dismissed. So rather than conducting its own investigation, Experian commissioned a third-party public records vendor to verify the dispute, and they botched that. 9th Circuit said, well, that's a jury question, where Experian could have caught the error if you had just looked at the court record. It's true the error in Dennis was clearer than here, okay? But they say the fact is Experian couldn't have known whether it would have found any information unless it had done a minimal investigation. So it's saying, look, Experian, you're saying, well, if we had looked at the bankruptcy record, it would have been confusing. 11th Circuit saying, but you didn't even look. Like, you should have looked. Okay? So when you do nothing, then we're not going to grant you summary judgment. So it did nothing, although it easily could have done something with the information the consumer provided. So here's the account number, discharge and bankruptcy, explanation of the rescission. So where Experian didn't even check the bankruptcy docket, that could be enough. And they say, look, to be clear, our holding is a narrow one. We cannot hold that your procedures were per se reasonable, but we're not going to say they're absolutely unreasonable. So it's a jury question. They're saying to the consumer and to Experian, guys, go present your argument to a jury. A jury will decide, not the judge. The judge made an error here, made a mistake. By throwing the case out, a jury should decide. Maybe they'll rule in favor of the consumer, maybe in favor of Experian. Go find out from a jury. Nor do we hold in every circumstance where a plaintiff informs a credit bureau of an inaccuracy, the agency must examine court records. Well, tell us what you mean, court. Maybe circumstances, maybe consumer supplies insufficient detail. This is why I'm constantly harping on these real vague disputes. Look, sometimes there's a reason to do that because you know the furnisher knows that it's doing this wrong and you don't care about the bureaus. You're just using the bureaus as a vehicle to get that ACDV to the furnisher, and don't sue the bureaus then. But if you want to sue the bureaus, make sure you provide detail. So they're saying if you don't do enough detail, then there might be no question about the reasonableness. Or the facts may show the agency took alternative steps. Maybe they contacted the consumer and say, well, we're not going to go to court. We're going to call the consumer. I'll just tell you, they never do that. Okay. We put these people under oath. Can the investigators, can they make a telephone call? Nope. Can they get on the internet? Nope. Can they take notes? Nope. Do they even have a pencil and a piece of paper on their desk? Nope. I mean, they can't do anything. Okay. But the court's just saying, look, there could be a possibility. Maybe they call the consumer. Maybe you don't give them enough details, and that would excuse them, but that's not the case here. But the facts of this case, number one, provide sufficiently detailed notice. Number two, did nothing other than forward the letter to its data furnisher, and then they just parried it back. We cannot say the procedures were reasonable. Now the court says, but the violations were not willful. And willful is running a risk of violating law greater than the risk associated with a reading that was merely careless. Talking about misinterpreting the law. And they say, well, it could have reasonably found support. Here's a Ninth Circuit case says reasonable investigation consists largely, but I'd point out not exclusively, of triggering the investigation by the consumer. And in Collins, we rejected a willfulness challenge. Taking no steps other than contacting only the data furnisher might have been negligent, but willfulness or recklessness is a higher standard not been met in this case. I will point out the problem is, if my memory serves me correct, in Collins, this issue wasn't raised, and so the 11th Circuit kind of punted that and said, well, we don't have to address that. And the problem is they told Experian, they told the credit bureaus in Collins, you cannot solely rely, unless it's some weird case, cannot solely rely on the data furnisher. And so everybody was on notice after. I think that is a weak part of this opinion. I hope that they will correct it or in future cases correct it, because I really believe willfulness should have gone to the jury there. And so they say negligently violated E and I by failing to undertake reasonable procedures. And so what they're saying is there's enough of that to survive summary judgment. So I will put a link to this case. You can just find it on the 11th Circuit website. And again, you can see the date here. A really good opinion. I think they made a little mistake on the willfulness that I wish they hadn't made, but overall it's a very good opinion. It really guts a lot of the arguments that these bureaus and the data furnishers make. So very, very helpful opinion. And I appreciate you guys watching this. Hope you found it helpful. And I'll talk to you tomorrow. Have a good one. Bye-bye.